weight in court. So whenever you write your statements, always remember good and bad. Even if you've got lots of bad to say, there's always one positive. I mean, at the very least, you've seen Guardian's analysis where they say the parents clearly love the child. And that might be the only positive they can put, but at least they've put one, you know? And so always think, what are the positives that I could put in there to counteract and to show that I've considered both sides? The second issue then is, so it says there, what are the positives? Do the negatives only go so far? So again, I always think fair and balanced. You must think about what's appropriate to say and what might be taking it too far. So for instance, I've had a case with a mother who would misuse cocaine once a month on the weekend when she got paid, and she would make sure that her child was with grandmother for that weekend. And the social worker went to town about how misuse of cocaine is bad for the children, bad for the child, how it places the child at risk of harm. And don't get me wrong, that's absolutely right. But what the social worker didn't do was consider, well, actually, that risk only goes so far, because in fact, if the child is with grandmother for that weekend and doesn't know what's happening and thinks I'm just visiting granny for the weekend, which is common in many families, and it's only one weekend a month, and mom makes sure she only uses for that weekend, is that a manageable risk? Should she have analysed, can that risk be managed? What are the actual implications of that for the child? And is it something that can work as an arrangement long term? The answer might still be no, and there might be good reason why it can't work long term. But she didn't go that far to consider that actually this negative, this issue of misuse of cocaine once a month, was only going so far. It wasn't just a whole picture of a lifestyle of cocaine. Hi, Louise. I've just seen your question about adult situations. I'm a children law specialist, so this is a session specifically for children, I'm afraid. However, can you just drop Lee an email to say that that is something you're interested in? Because in fact, we do have adult specialists in chambers, and I would say that one of them could put on a session for exactly what you're looking for. So I'm sorry about that. My examples will be relating to children experience. I'm sure that in fact, a lot of this can still be cross-applied, but the examples I will use will be children specific because that's the area I practice in. I'm sorry. Okay, guys, so let me continue. The other issue then is not only do the negatives go so far, but are there any safeguards to mitigate the risks that can arise? So for instance, the issue of the mother on the weekend, the one weekend a month, if she is only using cocaine for that weekend, is the grandmother a safeguarding feature? Does granny know when this is happening? And can granny make sure that the child only returns to mom's care after mom is clean, it's out of her system, and she's functional again and able to offer proper care? Again, the answer might be no, but I do think your statements need to consider that. And then it says, is there an analysis that brings this all together? So all of those factors coming together in one beautiful statement is what's going to help the court to see that that's what you've done. You've had a fair and a balanced approach. You've considered both sides. You've considered how to mitigate risks, who could support, how far the risk goes. And overall, you're still against mom for these reasons. Now, the second point, properly evidenced case. There I've written, remember the binary system. And I want to flag that because there is a piece of law in children law that says if something is an allegation and all it is an allegation and social care decide that it's not going to try to prove it, you as a social worker cannot rely on that to hold it against families. So for instance, I've had several cases where people, fathers in particular, have a record of domestic abuse allegations against them, maybe from 2 or 3 partners. And social care will do an assessment to say he's a perpetrator of domestic abuse. Yes, sorry, I'm stopping because I'm reading the chat at the same time of speaking. This session will be recorded and put on YouTube as well, so you can see it after. Yes, Kate, Lee will send you through the link. So he has maybe 2 or 3 partners in the past where they've reported that he's been domestically abusive, and what's happened is social care have gotten involved, seen the police records, which are only summaries of things anyway, and gone, he's a perpetrator of domestic abuse, he should only have supervised contact with his child. Well, actually, have you taken an allegation against someone and treated it as fact? Anyone can say anything about anyone. That's the world we live in. There are many people who make allegations against people. But unless you go through a court of law and you are either convicted or found in the family court to have done a particular thing, you as social care shouldn't be treating that as fact. We will come on to discuss that more, but I say that because you have to be very careful with that. I recently had a team manager, get in the witness box and say to me that I was for dad, and the parenting assessment was written and ruled him out entirely on the basis that he was a perpetrator of domestic abuse on these historic records that were years old, that they didn't bring these people to court to say, no, he definitely did that. They didn't bother getting in touch with the people to check if that was true or if they were making it up at the time. Dad denied it. And you remember the case of Rie we just looked at. If you can't produce the witness, you're in difficulty. Dad denied it, and she got in the witness box and said, well, it's on the balance of probabilities, so I think he's done it. Well, the balance of probabilities isn't a test for a social worker to apply. It is a test for the court to apply. And if you think that there is an allegation on the table that is relevant to your assessment of a parent, for instance, domestic abuse, you need to be flagging in your statement to the court that this is a relevant issue. I will need clarity on this. We therefore need to have the court explore and litigate this issue and either make the finding or not. Because if they don't make the finding, then it didn't happen. But if they did, then you've got something, a fact to work with. So be careful with that. The binary system is if you haven't proven it, it hasn't happened. That's how you need to write your assessments. And sadly, that does mean that sometimes you have, say, sexual abuse allegations from 1987. You can't find the witness, the records aren't kept by the police, but you as social care can't then turn around and go, I'm going to stop this man having a child. I'm going to stop him having a relationship with this child, because that would be wrong. You haven't got that record. You haven't got a fact proven in a court of law against him to say he is therefore a risk. And as I said, it's because the simple reality of it is an allegation can be made against anyone. We should never just treat an allegation as fact until it's proven in a court. So properly evidenced cases, don't treat the allegation as fact. Base your views on something you can evidence. And so, for instance, I've written there contact issues. That was more a prompt for me to remember this example. I had an example with a social worker who said that mother should only have contact with the children 6 times a year, as opposed to fortnightly, which is what she wanted, on the basis that her conduct in contact was poor. But that was all she said. That was all she said in the statements. Then when she got in the witness box, she was asked, when has mother's conduct been poor? Oh, there's been examples. Well, when? Give us the date of when it happened. What are you saying mother did? Were you there and did you see it yourself, or are you regurgitating hearsay evidence? And of course, she didn't have dates and specific incidents at the tip of her finger, and she couldn't go anywhere with that. And she was saying, oh, it's happened. I can't remember when, but it's happened. Mother can't defend against that. It's happened, I can't remember when, but it's happened. That's not something that someone can answer to. And actually what you need to do is base it on something you can evidence. So what I mean by that is, if you're saying her conduct in contact has been poor, you then go on to say, for instance, on X date, she did this. On Y date, she did this. On so date, she did this. And you say there, I observed this, or the family supporter worker observed this, or the contact worker observed this, because everyone then knows what is in your memory and what you're taking from records and exactly what you're saying happened on what day to show that her contact has been poor. So just remember that, base it on something you can evidence, base your conclusions on something you can evidence, and give the evidence. Do you remember the point evidence explanation that we had in school, where they used to try and teach us when we write essays, make your point, give an example or evidence it, and then explain yourself. And that's almost the same approach that you need to take. The point is, she's had poor contact. The example is on X, Y, and Z date, she did this, and it was observed by me or someone else. Therefore, she has not been able to conduct herself appropriately, and ongoing contact on a fortnightly basis would be harmful to the children. That's how you explain it. So then I've written there, to help you with this, when you come to writing the evidence, when you come to writing, this is the evidence of what happened, who saw it should be written, what did they see, when did it happen, what did you do about it, and did it make a difference? And what I mean by that is, let's stick with the contact for a minute. you would put on the 5th of March 2020, I observed the mother to snatch something from the child's hand, which made the child cry. I then spoke to her about this to say that this was inappropriate, and she told me to shut up. Therefore, in future contacts, I've observed this behaviour repeating itself, and sadly, having spoken to her did not make a difference. And in that, I've addressed who saw it, me. What did you see? Snatch something from the child. When did it happen? I think I gave you the date at the start of that example, and I made up a date, so don't ask me to repeat it. What did you do about it? I spoke to her about it. Did it make a difference? No. And so when you are writing, your statements, you're trying to make points against parents, please make sure you think about that and put that level of detail in, because that is what we need to prove cases in court, rather than the examples being in your head but not on the paper, because then it isn't persuasive. Holistic analysis then, well, I think you've heard that term so many times, and I think everyone has a different understanding and a different meaning when it comes to understanding what holistic means. For me, I always think of it as seeing everything in the round, bringing it all together and making sure that you don't just look at things in isolation. So look at everything as a whole, and what that means when you're writing your statements. If you're, say, writing a statement to make a point that a particular person should not have care of a child or is a risk to a child, make sure that you do a holistic analysis by looking at that and thinking, well, if there is a risk here, is there someone else that can help with that? So I put there, can family help or prop up the parenting that might be lacking? A lot of people will struggle to care 7 days a week, but they might have granny come in 5 days a week to help around the home, and that is enough. When you do your analysis, make sure you don't exclude granny from the home and what granny can do and whether or not that plugs the gap. It might not, but you've got to include it so that the judge knows you've thought about it. Can the risks be managed? And again, I've put there occasional drug use. You already heard what I said about the mother that was using on the payday weekend. That's the same thing. Who can be a watchful eye? And again, this is just looking at things in the round. There's not just a risk. You have to think about how far does that risk go and how do we manage it? So a watchful eye, for instance, let's use our example of the mother that uses once a month. The watchful eye could be the child goes to school 5 days a week, mother drops off in the morning and picks up every day. Therefore, if mother is misusing Monday to Friday, a professional may well be able to pick up on signs that show that. That can be a way of making sure that you watch, you safeguard to make sure her usage is only limited to that one weekend a month. A family support worker might be going in twice a week and can observe her at that time. You as a social worker might be doing unannounced visits under a child protection plan, visits even. And those are safeguarding features. Make sure you consider them in your analysis. And what I mean by that is, even if you think the risk is this, this, and this, and I'm going to have to take this child off her, just include a couple of paragraphs that say, but I've thought about this, and this, granny's help, school support, me going in unannounced, and I just don't think it would do for these reasons. And then your court can't criticise you for not looking at everything in the round. You've not excluded an important factor that may mean that the child will be safe. Do two insufficient parents work together to become sufficient? I've written there. That's me writing it as clumsy and as best as I could at the time. But the logic being, I've had cases where you might have a mum that can only do it Monday to Friday, but a dad that can only do it Friday to Monday. And then actually, do you need to remove that child, or does shared care work in that setting, even if there are risks that need to be managed? Make sure you think of everything in the round and how two people who on their own might not be able to do it might fit together to do it. I recently had a case where we had a mum and a dad, and to be fair, dad was a bit useless, but mum was doing her best, but she couldn't do it all. She had she used to drink in stressful situations, and we could track when that was going to happen. And at the final hearing, whilst we said no, child couldn't go back to mum, the mum's team argued, well, you've negatively assessed 5 family members who on their own couldn't do it, but there's nothing that's such a significant safeguarding concern in respect of each of them, that if they each stepped in, say, to help one night a week ever so often, that couldn't plug the gap. And again, sometimes that's what you need to do, is even if you negatively assess family, think about, well, they might not be able to do it as a whole, but is there anything stopping that particular family member coming in to help mom do it? And does that plug the gap that mom might have in her parenting assessment? The answer might be no, and it was no in my recent case, but it did give me a headache to try and figure out how to get to no, because I had to justify it in court. So yeah, so that's what I always think holistic means. Let me tell you another limb of holistic that I think a lot of social workers leave out when they write statements. You do have family group conference in Leeds to try and do this. Absolutely, Sharon. But I also think the reason I'm saying these things is not because I'm saying social workers don't do them. It's because sometimes I think you think, oh, I've done that, but then you don't put it on paper. And what takes a good statement to a great statement is to put that on paper. When you write it to say, these are the risks for the family, you then throw in a couple of paragraphs saying, we have tried to mitigate, we have looked at these factors, and this is where we get to. So yes, you do have family group conferencing, and regularly that comes up in court, because I do a lot of work in Leeds, but it comes up in court once it's raised as a challenge to the local authority's evidence, whereas actually you should put it in your initial statement, you should put it in your final statement, because then no one will raise it as a challenge. They'll know, and the judge reading it will know that you have already looked at that option. So then, coming on to the second part of this, I've written, consider the child's individual needs, and that this is not a generic child. Now, every child has something about them that is unique. And sometimes what they have that is unique to them is not just unique to them, it might be unique to their age. But I think sometimes where social worker statements are lacking is they don't make enough of that. And let me give you an example of that. I recently had a very young child, a 4-year-old, who sadly will have to be in long-term foster care because we didn't get the plan of adoption approved. And what caused me real concern was, and I told the social care team afterwards, is that actually the plan of adoption was probably right, but they didn't do enough to highlight why that was right for this individual child. At the end of the day, a plan of adoption you might think, well, if the parents can't do it, adopt. The court needs to see that you have considered that adoption is the right option. And for this particular child, what they had was this. Me reading the papers, I managed to pull this out, was they were 4 years old, only just become 4 years old, and in the 3 years that they've been on this earth, they had been subjected to and exposed to quite horrific domestic abuse, which meant that they were quite emotionally fragile. They were clearly traumatized from their childhood experiences. And as a result, you as social workers know what they need is stability, predictability, and security to help them to overcome the childhood trauma. Otherwise, without this, they will grow up to become adults with emotional and psychological difficulties, and also adults with attachment issues. What the 3-year-old going into 4 also needs is a primary attachment figure or figures that they know will stay with them for life at this stage, and by life I mean their minority, to make sure that they embed and they understand that and they recover from these past experiences. Was any of that specific? And that is very specific to that child. Were any of those specifics in the social worker's analysis when it came to promoting a plan of adoption? No. So when I then put it to the court in submissions to say, Your Honour must consider this child's particular needs, the judge turned to me and said, well, Ms. Persaud, that might be right, but what you're saying to me isn't evidenced. Nowhere in the statement has the social worker said that this child has these particular needs, that due to their age and their trauma and their past, this is what they need right now. Therefore, a plan of long-term foster care would not be right because of the higher risk of placement breakdown. And in fact, what they need is a placement that we can almost be certain, albeit they do break down occasionally, but we can almost be certain that an adoptive placement will give them that. And we lost that case because of a lack of proper analysis that applied the child's specific and individual needs, life experience, age, and what they need at that point, their attachments to the plan that you're going for. And I raise that for social workers to think about, because I always think, include that in your analysis, that it's not just looking at what these parents can provide. Let me give you another example. This case I just told you about, where we got to court and mom's team was saying, well, mom can't do it, but with family support she could. The reason I was able to successfully convince the judge that's wrong was because of the same thing. We had a very similar situation with a child who had been subjected to domestic abuse, and therefore, due to their past experiences, already had signs of anxiety and self-harming and needed very predictable parenting, and as a result could not be in a setting where mom uses alcohol and passes the child to a relative every time she needs a drink, because it would bring too much instability. Thankfully, the social worker did get that point in evidence and made that point to the court, and that is what I mean, is you need to bottom off and address those types of things in your analyses and in your statements to make sure that you don't just write there's risks to a parent. Also think about the child's particular needs and match what the parent can provide to say it's wrong. So let's weigh this all together, and I've given you some sentences there that I think might help, that if you in future can incorporate into your writing. The child's particular needs are, bam. The positives are, as in what can the parent offer. However, the negatives are, bam, which mean that the risks to the child are, bam. I have considered how to mitigate the risks. I have considered, and that's where you go, professional support, family support, the safeguarding features around the child, who would be seeing the child and whether that reduces the risks. And then you go, the risks can or cannot be mitigated for these reasons, and that is your analysis. Even though professionals will be there, mom is a dishonest person, so we can't trust that they won't miss something. If the child is to be exposed to the risks, this could affect them in this way. And then you go down and list it, applying what you've already written about the child's particular needs. Therefore, on balance, the risks outweigh the positives and do not meet the child's needs because, and that is your conclusion. So I've written those few sentences there, just even if you reword them, just to give you the idea of how you should be looking at this and what you should be addressing at every stage. So nail everything down and put the final nail in the coffin if you need to, but just make sure you don't miss anything as the social worker, as the expert, putting the fair and balanced evidence before the court. Now, I've written there proper identification of risks. When you do your assessments, when you do your statements, you want to make sure you get your risks right. And the reason I've done this, and I won't take long with it, is because I want to point out a very blatant one to me. What isn't a risk? Now, it's dishonesty. You've seen there I've identified physical, emotional, sexual, and I've put psychological in brackets because it's arguably emotional, but I always think of it as a separate limb by itself. And I suppose neglect could go on there. Neglect is a risk, so I've left that out. See, even I have my moments. But what isn't a risk is dishonesty. Just because someone is a liar doesn't mean that they're not a good parent. And I have seen social worker statements where we've gone for interim removal or final plans of removal because the parents had lied. That isn't enough. You still need to show that they've done something that is risky, that they've done something that will either hurt that child or would hurt that child in future. But where does dishonesty come in then? Because you're going to say to me, I have so many families that are dishonest, Regan. You're telling me that I can't rely on that. No, you can, but for a different reason. Once you identify the risk, so for instance, the risk is sexual harm. Mom is dating someone, or mom is seeing someone who is a known paedophile. And the court will say to you, well, what if you put a plan in where she's not meant to see this person is not meant to come to the house? You're going to say to the court, that plan doesn't work because she has a history of dishonesty. And that's how you link in dishonesty. It's not a risk on its own. And you never say, if someone says to you, what are the risks in the case? Dishonesty is not a risk. Don't say dishonesty. I've had so many social workers say dishonesty in the witness box at me. It's not dishonesty. The risk is sexual harm. The risk is emotional harm, physical harm that can arise out of X, Y, Z. The problem is I can't mitigate that risk. I can't manage that risk. I can't keep that child safe as the social worker because of the parents' dishonesty. Written agreements wouldn't work. Visits won't work because they'll hide things. Speaking to the child might work, but you still need the parent because if the child doesn't speak up, I need the parent to speak up. Offering support won't work because they're not going to tell me what they need because they distrust me. That's where you link in the dishonesty point. And I raise that because just be very careful in how you write your statements. Dishonesty is part of the holistic analysis that you do around the risk, but it's not the risk itself. Okay, guys, and this is the bit I've come to now, the drafting skills, the do's and don'ts of drafting. And I haven't written everything here, but what I've tried to do is name some common pitfalls, and to tell you then when you're drafting, how you're going to craft yourself a compelling legal argument. Well, what you're going to do, now that we have all that information that I've just given you at the back of our mind, we're going to name the person appropriately. And again, I've had social work statements where it does this. So let's read the don't, and then you'll understand exactly what I mean. She told me that in March she didn't speak to him. He told me that his brother helped them to reconcile. He then told me this is true. Well, who is she? Who is he? And when is he referring to the man and then referring to his brother? It's not clear. And I've seen social workers do this without realizing it, is they're writing it as they would explain it. Make sure that when you write, you're very clear about who you're talking about, name the person, and make sure that you name the relevant person throughout, and only use pronouns where appropriate, because otherwise you lose sense. And if you lose sense, the judge doesn't know what you mean. Then I've written, base it on evidence, not speculation. And I have had a case like this where we went to final hearing. The parents had said that they'd not been together, I think for about 6 months in that case. And the social worker said, they're definitely together. I just know that they're together. It's in my gut. I've got a social worker gut about this. I hear that a lot. And I'm sure you do. I mean, I have a lawyer gut. I've worked in child protection so many years. You sometimes just know when something's off, don't you? Or you know when someone's not telling the truth. But sadly, you can't use the gut to justify it. So if there is no evidence that they were together for the 6 months, you need to admit and say, there is no evidence to say that they are being dishonest about this. I have not found them together. I've not seen them texting or calling one another. There is no evidence of this. And you must accept that. Use proper evidence. And this is the example that I spoke about earlier, where we convict people. So I put, do not convict people yourself. But what I mean by that is, don't just look at the police record, which is old, which is a summary of things people said. And you know, to be honest, don't forget that police officers are people too. And some of the times, not a lot, some of the times, they can make typos when they're typing things up. They can get things wrong. They can end up over-exaggerating a situation. Many of you work with officers and you've seen their notes after the event and you think, hold on a minute, that wasn't what happened. They have their own spin on things. And then you've gone in as judge and jury and convicted some poor dad on the basis of these logs that the police officers have pulled together. Just be conscious that an allegation is just that. It's an allegation. It doesn't mean it happened. It means someone has alleged it's happened. And if you wish to say that in fact he has done that, and that is relevant for your assessment, you need to flag that as something the court needs to determine whether he's done it or not. So I've written that there. Use proper evidence. Don't convict people yourself. I've written there, write in the active so we know what's being said, so we know who has seen this. That is the point I made earlier, and I'll reiterate it here. I've seen so many statements where I've seen things like, the home conditions have been observed to be untidy, the bedding is dirty. Well, who observed it and when? And is this something you saw, or is this something someone else saw? We've been raised to write in the passive, where we think, and it is right, it looks more eloquent to write the home condition, the home has been observed to be. And so there was this natural inclination to not go, I observed this the home to be, or the family support worker observed the home to be. But actually that is exactly what we need. Don't be scared of putting I in your statement. It's your statement, it's your words. So if anyone should be saying I, it's you. Because what can happen is you end up in court and they say, and you get in the witness box and they say to you, who observed the home to be dirty? Because mom's saying it isn't dirty. And you say, oh, it's the family support worker who doesn't work for the local authority anymore. Well, we can't convict mom on that quality of evidence, but the way the statement was written, I thought it was you that saw it. So you have to be very clear. I saw this, or someone else saw it, and who that person is. So everyone knows if it's hearsay evidence or if it's primary evidence, because then when your legal comes in, when your barrister comes in, I will look at it and go, okay, so she can give me evidence on that. So I'll examination in chief her on that. We need to get these statements to bolster the case, but I can't do that if I don't know what you've seen and what you haven't. I'll put there, rely on your strongest examples. And what I mean by that is, you've seen the example I've put there. Sometimes we work with families and we work with them for donkey years, 10 years. Don't necessarily rely on examples that go back lots of years. Try and focus on the last 2 years and just pull the most relevant examples out from that. If you've got something last month, if you've got something the previous month, that's much more relevant than something going far back. Pick your best examples, because as social workers working on the ground with families, if they're going to court, chances are there's many examples. So you want to find your strongest and your most recent ones. Evidence your reasons to worry. And I've put there, do not destroy your irritations with the family. So I have a case at the moment where I'm for a mum, and what the local authority did was, she's got a partner who is technically, he has had, again, allegations from, I think it was 2018 or 2019 of domestic abuse. And she's pregnant, and they've gone in saying, he's a risk, you can't raise a child with him, blah, blah, blah. And mum's gone, well, you might have said he's done that in the past, but I don't know if he's done it because you're not showing me any convictions. And also, he's changed. He's not like that with me. Now, rather than the social worker going, I understand what you're saying. I'm going to send you on a domestic abuse course, or we're going to do some domestic abuse work so that you can understand that even if he's behaving differently now, these behaviors can resurface. There are reasons people act like this, and look out for these signs that will tell you that. She's just condemned mum. She's gone, because mum's saying that, mum lacks insight, mum will stay with him and the child's at risk, and she's prioritised him over the child. Well, is it that subtle in family life and in relationships? I don't think it is that subtle. And actually, I think what that social worker failed to do was some actual social working, was working with this mother to help her to understand risk, the difference between risk and actual harm taking place, help her to understand that the past is a reflection of behaviours that can manifest in the future, and then helping mum to get her to a position at where she can make an informed decision. So as you can imagine, when I was instructed on the case, I took it back instantly for an interim contest, and now baby's at home with mum whilst they do work with mum before they make their final plans. But it's because that social worker didn't properly look at it. And the reason she didn't do it was because, as I said there, she threw her irritations with the family on the paper. She just thought, oh, I can't be doing with this. Mum clearly won't listen to this, and I'm not going to explore it further. She lacks insight. And sadly, when she gave evidence in court, that's how it came across. So just be conscious is that explain your reasons to worry very clearly, what you've done, what you haven't done, and why you still remain concerned. But don't get so frustrated with family members who might be aggressive or who might be dishonest and just rant on the paper. Always keep that in the back of your mind and reread it and think, is that a rant, or have I done that right? So then let's look at proper application of the welfare checklist, which is the last part of what I want to cover with you today. Now, you know that when you do children work, there are two checklists, the welfare checklist and the adoption checklist, if you're putting a child up for adoption, if you're trying to go for a placement order. And the reason I wanted to mention this is part of statement writing, and it's all about how you're crafting statements, how to address things, how to word things, is time and time again, I've seen social workers use the checklist to justify their plan. And a very good example of that is the one I've written there, is the adoption checklist factor, which is the likely effect of the child of ceasing to be a member of the original family and becoming an adopted person. I've seen social workers write under that heading, the parents will be able to send Austin, I've picked a name, a letter once per year via letterbox contact. How is that an analysis of the likely effect on the child of ceasing to be a member of their family? Well, that isn't. That is justifying your plan of adoption. That is you putting down, well, the plan's adoption, this is what will happen anyway. And actually what you need to do under every single limb of that is, I acknowledge entirely that by this child ceasing to be a member of his family, he will lose birth relations. And as a result, a part of his identity may well suffer as he grows older. I acknowledge that this will have an impact on him when he does find out that he's adopted. I acknowledge that, in fact, it is important for children to be raised by their own families if they can, to understand their roots and their heritage. And I acknowledge that all of this will be lost. However, due to the risks in this case, as identified at factor X above, this has to be something, this is a necessary this is a necessary harm that the child will have to suffer, or this is something that will have to happen to ensure that the child's other needs are met. Something along those lines. But then the court will not go, this social worker is just using the checklist to justify their plans. They'll go, she's balanced, or he's fair. They've accepted that in certain places there is damage. Oh, bless. Thank you, Louise. And that is very important for you to do. So make sure when you look at the checklist, use it, be fair, accept where your plan might cause harm, but also accept where it's necessary. It's a necessary evil. And I put that one, the likely effect of ceasing to be a member of the original family, because that's the one where normally social workers are really scared to acknowledge that, and just acknowledge it. It doesn't mean your plan is wrong. It just means that there are many competing factors, and when the court throws it all in the balance, the scale has to tip in favor of adoption. Another point to make is, remember to use the right one. The amount of times I've gotten to final hearings, looked at the statement, and even though the plan is adoption, we're using the welfare checklist. So always when you get to that, think, oh gosh, if my plan is adoption, let me use the right checklist. Highlight the positives of your plan. By all means, there will be once a year letterbox contact, but accept the negatives of your plan, that this will cause this has the potential to cause long-term issues for the child. Link it to the child's specific needs. And what I mean by that is, let's pick a child, Leah. Leah is a 6-month-old baby who cannot meet her physical, emotional, or psychological needs. She's of an age where she needs a primary carer to form secure attachments. That is relevant under the heading of the child's needs. Absolutely relevant. And what you've done there is you've linked it straight to Leah rather than a generic child. So make sure you do that. And then I put there, do an analysis as you go along. And that's exactly what I just did with the likely effect of ceasing to be a member of the original family. Is you analyze the negatives, but you said it is necessary because of the risks as highlighted above. And that is okay. That is your analysis. Make sure you do that under every heading to make sure that overall, when you reach a conclusion, no one can say you didn't think about it fully. So we've gone through today, and I've only had limited time, but I've done my best to give you a little insight into the law that would be relevant when you come to writing statements. We've gone through the style of writing and the way you should word things. We've gone through the different factors that you should consider when it comes to evidencing what you put in statements, how you present it to the court in a holistic way and in a fair way, and how you should consider the child's individual needs. We've gone through how you link in dishonesty without actually saying that dishonesty is a risk. And finally, we've gone through how you go through the different welfare checklists to get to the conclusions of your plans without just using it to justify your plan, but using it appropriately so that you look as the expert in court and the person who's done a very fair and balanced and reasoned job. I hope that is helpful to everyone. I know I've gone through it relatively quickly, and I hope you all get the handout. If you do have any questions, please feel free to get in touch. By all means, if you have any questions, I'll take them by email, I think, because I know some people need to go rather on here. But I'll stay on for a couple of minutes in case you have got any questions. Please just stick them in the chat. Otherwise, thank you for attending, and you can leave if you don't have any questions. I'm just looking to see, are we able to share the Word document with team members? Yes, yes, you are. You're absolutely, and please do. Please share it among social workers. I'm just looking down. You're very welcome, guys. I'm getting lots of thanks. Very welcome. Yes, you can share with your social work students. Of course you can, and thank you. It should be available either today or tomorrow. Lee will make sure that he emails you around once the recording is available on YouTube. Lee has advised he will arrange an adult session too. Wonderful. Wonderful then, guys. Then it looks like you haven't. So using the email, we can request for an adult. Yes, you can. Yes, and actually it seems that Lee will advertise one in a moment anyway. So then you should get that. Okay then, guys. Any other questions you've got, please let me know. And otherwise, thank you for attending. We'll stop now.